SJC-11792, Commonwealth v. Pavel Lavrinenko.
Thank you.
Good morning, Mr. Schnipper.
Good morning. May it please the Court. I'm Merit Schnipper for Pavel Lavrinenko. At its most basic, the defendant's refugee status means two things. He had a subjective fear of religious persecution if he was forced to return to Russia, and the federal government credited this fear after making an objective assessment of the conditions faced there by Pentecostal Christians.
Well, I'm a little confused on the record here. I mean, he came when he was a youngster.
He was 13 years old.
And is there anything to suggest that the evaluation was done of him or of his family? And it was his family's fear of, the adults in the family who had a fear.
Yes, I mean, it's considered, the term is,
so that just passes
it's a derivative.
So when you say subjective fear.
Well, what I mean by subjective fear is that the Supreme Court, in construing this statute, has, in two cases, said that the determination is just as a clear matter of statutory construction, and INS v. Cardozo-Fonseca says this is based in part on the refugees' subjective experience of conditions in their home country.
But the question is, when the judgment was made, was it an individualized judgment with respect to your client, or was it really looking at his parents?
I think it's looking at the family group. I mean, I think in this case, a child, which he still was at the time of this plea as well, is, basically carries with them the experience of their families for these purposes. People often leave their home countries and family groups and receive these designations of family groups. Obviously, a child is not particularly well situated to give individualized testimony.
I'm just trying to find out what happened.
Yes, no, it's not 100% clear, but that's not fully in the record, but that is what happened. Yes, this is a family derivative determination.
And at some point, I take it he would have had an opportunity to, get a different status? Go through a different evaluation process and get an adjustment in his status?
Certainly he would have had that opportunity anytime after a year in the country.
Isn't he supposed to do it or not?
There's no supposed to do. I mean, if you're asking me whether it's well advised to do it, I would say yes, but it's not. It didn't happen in this case, and there's no requirement of law that any person seek asylum at any point.
So so there's been no evaluation since the family came here with respect to his status?
Well, there's currently an evaluation undergoing in the context of the deportation proceedings.
Right. Well, that's the product of a series of criminal adventures, but not the product of anything else.
Well, it's the product, significantly of this conviction as well as of others, you're correct. And it's so in other words, he never moved to get a green card or to adjust his status otherwise until he was subjected to deportation proceedings.
Gotcha. Right.
So
is the question of whether or not he is still a practicing evangelical relevant either in the immigration proceedings, or could it be relevant to a court in the midst of these proceedings?
Well, I mean, I think if the question is whether he would then somehow relinquish his religious beliefs and thus, I guess, be able to cure the threat of persecution in Russia, I can't really speak to whether a person, I can speak to my own background. It's not like if you stop practicing Judaism, then everybody forgets if they're going to get into anti-Semitic issues. Russia has a very severe record of persecution of non-Orthodox Christians at this point, and that's laid out by his Immigration Council in testimony and in the summary of governmental reports submitted. So I'm not sure.
Did that testimony that was presented at the immigration hearings, did it suggest that even if you relinquish, or if you relinquish your religion as an evangelical, you would still be subject to persecution in Russia?
There's no suggestion in the record of that one way or the other, although I would suggest to the court that the statutory nature of the refugee definition is one that contemplates inherent identity and persecution on that basis, and contemplates an international law treaty requirement of recognition of those bases of persecution, and does not in any way contemplate that a way a person could escape that is by relinquishing their identity.
But certainly someone who has refugee status can be deported.
Yes, that's correct, and that's happening in this case.
Yeah, and can be deported, and if there still remains a danger, can actually would he request to be reported to a different country? Or is it a possibility that he can be deported to a different country?
There is a possibility. I'm not, frankly, I don't know the procedure through which that would happen. I mean, the general presumption is that you're deported to your country of origin, and in this case, obviously, that's a country where conditions have progressively worsened for people of his religious background. So,
now, the special circumstances as set forth in Clark, is it your view that if there is a finding based on refugee status that constitutes special circumstances, that the ball game is over, and that requires a finding that he would not have pled guilty had he known?
I think that if we're past the deficient performance prong and into the prejudice prong of Clark, and I've certainly suggested to the court that the nature of the federal control over immigration and naturalization and the conduct of foreign affairs means that a federally recognized refugee would, by definition, place particular emphasis on any consequence and any decision that would lead to the consequence of being sent back to the country they had fled to escape persecution.
Okay, but then from there, let's assume we accept that. Does that mean, as a matter of law, that once you show that, then you've also satisfied the prong to say that I would not have pled guilty had I known?
Yes, I mean, prong 3 of Clark, particular circumstances showing that you would have placed a particular emphasis on immigration consequences of a guilty plea is satisfied by federal refugee status. That is one of my arguments. So,
Even though, without needing anything from your client at all, just the status?
well, I think the status represents a prior federal fact-finding on the exact question that the special circumstances inquiry of Clark.
So you
is
say as a
making.
matter of the supremacy clause, we're bound by that? Is that what you're saying?
I think that the state court judge is bound by that. If there has been an affirmative finding of refugee status, then there should be a conclusive presumption that the person would have satisfied special circumstances under the third prong of Clark, because this is not it's not a conclusive presumption in the situation where a person has fled just the terrible circumstances that many of these refugees are
It's the
fleeing.
refugee status you're saying.
But if there's federal formalized refugee status, that means that there's been a prior federal finding on really the same inquiry as the third prong Clark inquiry.
But the immigration judge wouldn't be subjected to that, such a weighty presumption.
Well, the immigration judge is making a different decision. He or she's not making a decision about whether the person has a well-founded fear of persecution. That the immigration judge is making a decision about, in light of the refugee status as well as the other attendant circumstances, in this case some criminal convictions, a person notwithstanding the refugee status should or should not be allowed to stay in the country.
So why doesn't that play into your alternative argument that if we're not going to recognize a presumption, it should get remanded to the trial court judge for findings that specifically address the question of whether or not he would have pleaded guilty in light of these particularized circumstances?
Well, I think that could be an alternative remedy here. I mean, I think what I've suggested is the alternative to the conclusive presumption is a look at how the federally designated refugee status should play out in the context of these Rule 30 proceedings.
And how does that need to be carried out? What does a judge need to do?
Well, I think the judge first needs, probably upon instruction from this court, to place an appropriate weight on that finding and to recognize what has gone into that finding, in this case, constitutes a federal government determination at the point of entry that the defendant fled severe conditions of religious persecution. So, to simply say the judge had that information before him, but he just said there's nothing to indicate any special circumstances here.
So it's a factor that has to be addressed, and the judge needs to address it in writing somehow.
I feel that the judge both needs to address it in writing, and I feel that the judge needs to be instructed, and future judges dealing with this very discrete situation need to be told that there are certain procedures that need to be followed to recognize what a refugee status really means, one of which is you're really cut off from evidence of the situation in your own country, certainly firsthand evidence. You've fled there and you've usually left behind both your possessions, your family and community connections, and all sorts of other usual sources of proof. You need to be allowed to, as I've suggested, introduce the same types of materials that refugees may introduce in federal asylum proceedings, like governmental and non-governmental entity reports on country conditions. You need to be able to prove your membership in a persecuted group rather than proving that you yourself would be singled out for persecution. And these are all procedures that the federal government's already adopted primarily because of the difficulties, well recognized and part of our treaty obligations, that these people face.
And the federal government doesn't have to deport him.
No, they
I mean,
don't. But
his plea of guilty here, this didn't result in a mandatory deportation, right? He has a whole track record of things that have contributed to this.
well, as this court has said in both Clark and in Scott, we're not going to analyze the prejudice prong as of today. We're going to analyze the prejudice prong as of the date of his guilty plea, you know, factoring in the one omitted piece of crucial information that he didn't have at the time he pled. So
Well, I know, but this is not pleading guilty to an offense which essentially required his mandatory deportation, did it?
I disagree. It really, well, what it does is he's a refugee, so he's in a separate subcategory of non-citizens, and a category of non-citizens who are eligible for discretionary relief from deportation, right? So
But this is not a drug case. This is not a drug case. He didn't get more than a year sentence.
But it's a crime of violence.
the crime of violence under federal law. So it's not a drug case, but I would argue that the consequences are every bit as clear. If you look at Padilla, which is the paradigmatic drug case, clear consequences case, the Supreme Court says the consequences are clear because you can just open up the statute and read it. And it says right there, an alien convicted of a drug crime is deportable. That's 8 U.S.C. 1227. So
Right.
by contrast, so you would have to flip through the Immigration and Nationality Act and read through until you got that provision. If you look at that act with specific reference to refugees, there's two sections that contain the word refugees in their title. One of them is 1159C, or 1159. If you look at subsection C, it directs you straight to 1182, which is the provision dealing with waivers of inadmissibility for people who are refugees convicted of crimes. So it really is a
Okay,
very,
go there, and that
Right.
takes you where?
it tells
So
you
he
that,
could apply for a waiver.
that's right, and then all you have to do if you're a lawyer is do some research to say, well, how does the assault with a dangerous weapon / crime of violence, which are, as this court has recognized, are identical terms, how does that interact with the waiver of inadmissibility provision under federal law? And you're right there. I mean, and of course, as I talk about in my
Okay,
brief,
and go on.
that's all you need to do.
And you're out.
And it tells you,
And you're
hello.
out. You're deported.
Well, no. What I'm saying is that if it tells you that if you're a refugee and you are otherwise deportable, you can be waived. Your inadmissibility can be waived based on humanitarian reasons and family unity. But if you do the research to find out what happens when you have a crime of violence on your record, you're moved from that to what's known as the matter of gene standard, which is only under extraordinary circumstances based on national security considerations or diplomatic considerations. And I would submit to the court that for a 17-year-old child living with his parents, working at a pancake house, a high school dropout, he's not going to satisfy the national security prong or the diplomatic consideration
But
prong of a waiver.
he actually got a waiver.
That's right, he did.
He did, and then it was
reversed.
sent back for additional findings because of his extraordinary amount or the extraordinary number of problems on his
Well, I would
criminal record.
hesitate to characterize them as extraordinary, knowing what this court sees coming across its docket. But, you know, the question isn't what happened in 2013. It's how he would have reacted in 2005 had he been properly advised. And at the time he had been in 2005, none of those other factors had occurred. Those are all things that happened much later in his life. At that time, he was moved from the humanitarian relief category to the extraordinary circumstances category solely by this conviction.
At the time a refugee enters the United States and is granted refugee status, do they receive any instructions about the potential consequences of criminal conduct?
I don't believe so, but I can't authoritatively answer
Can
that
a
question.
judge, in the posture of this case, consider the defendant's past criminal conduct on the question of whether or not he even cares about whether or not he's deported?
Well, it's quite clear that the judge in this case did do that.
Is there anything improper about that?
The only thing that's improper about that is it needs to be filtered through the lens of how would this have impacted the defendant at the time rather than now. So, no, there's nothing improper about that if you're going to the consideration of, well, you know, what can we find that the defendant likely knew because he had had some prior experiences with the criminal justice system. These other convictions had a certain impact, but I would point out to the court, and this was well established in the proceedings below, that this conviction, as his immigration counsel testified, stands alone in its impact because he did have 2 prior crimes involving moral turpitude, which made him that baseline deportability, he gave him that baseline deportability, which is why this waiver provision for a refugee became so paramount.
But Homeland Security also asked the hearing officer to make certain findings with respect to other offenses.
That's correct. So that's how it played out in the years following this plea, but that has no bearing on how he would have reacted in 2005 if he had been told, hey, pleading to this drug driving offense, pleading to leaving the scene, none of these are going to impact you. But just so you know, if you're going to plead to the assault with a dangerous weapon, you're never going to be able to get a waiver of inadmissibility. And if the federal government ever gets a hold of you, you're going to be sent right back to the land where you fled religious persecution. And I would point out, without your family, to a country where you have no further relations and you're 17 years old. So I think the prejudice is severe.
To prevail here, I know you're over the time, but to prevail here, you would, of course, have to show that the judge was clearly erroneous in finding that he would still have pled guilty, correct?
I think that's correct, yeah.
Now, clearly you can, well, plainly you can show it's clearly erroneous if you get your conclusive presumption.
Yes.
If you don't, if you get a rebuttable presumption, or if you get a weighted factor analysis, what happens?
Well, I still think we should win on this record because we've shown not only his statement about how he came here all by himself, he had no family left in Russia, the evidence of religious persecution we've submitted through the State Department reports, Immigration Council's testimony about so I just don't see anything countervailing the idea that a person at 17 years old told, hey, this, I would point out, relatively weak fact, assault with a dangerous weapon conviction, is really something you got to avoid. Otherwise, it's a direct pipeline back to the place you fled.
Could I ask something really quickly? When you get to the waiver of admissibility analysis, does the fact of the crime have anything to do with it, or is it just the label that's attached to the crime? Because I'm remembering your description of what happened here.
Sure.
And it's not like your typical crime of violence.
No, it's not. So the standard is in flux in terms of how the federal courts are dealing with it. I mean, there's a lot of, this is mostly Armed Career Criminal Act stuff, but there's moving from the categorical analysis, which is what was in place in 2005, to the sort of multi-factor or going below the labels, which is what's kind of gaining ascendancy now. So I would say at the time, he was looking at the categorical analysis, the crime of violence. Now I think you're moving more into a looking below the surface analysis.
All right,
Thank you very much.
May it please the court, Cynthia Payne for the Commonwealth. Commonwealth is asking this court to affirm the motion judge's order denying the defendant's motion for new trial. Although it's the Commonwealth's position that the motion judge properly denied the defendant's motion, the judge erroneously found that that plea counsel's performance was deficient. Here, as was noted by Justice Cordy, this charge, the assault and dangerous weapon charge, was not a mandatory deportable charge. This charge did not bar the defendant from a waiver of criminal inadmissibility. This charge, and as such, all counsel needed to do was what he did in his general practice. He could not recall the specific case, but again, his general practice was that he would tell his clients he was subject to deportation as a result of this charge.
But he didn't, I think he conceded, he did not make inquiry as to whether or not he was an alien, correct?
A refugee.
That's correct.
An alien at all. He didn't even know whether or not he was a citizen, correct?
That's correct.
And he made no inquiry as to whether or not he was in the particular category of a refugee.
He indicated that he did not recall ever having a client. So yes, Your Honor, I would say that's correct.
So how can that be what we expect counsel to do, given the potential consequences?
On the facts of this case, because this was not a drug case, this was not a case that mandated deportation.
But it still has a pretty potentially serious impact on his ability to adjust status. I mean, you can't, and if he's deportable, even theoretically deportable, how is it okay just to not even know whether he's a citizen or not?
And isn't it contrary to performance standards?
Well, certainly, and again, 2015, where I would suggest...
Oh, haven't those performance standards been in effect for a very long time?
Certainly. This was a plea that took
place... And that
place...
would have covered this situation?
In 2005.
Yes.
Yes. However, again, based on the facts of this particular case with this particular charge, the plea counsel's general practice, the advice that he gave that he was subject to deportation, whether or not he knew this defendant was a refugee, or whether or not he knew his status, would not have changed.
Do you really need this argument?
No, I would point out one thing that was brought up on my brother's argument. This case did go before an immigration judge. This case was sent back by the Board of Immigration Appeals, which indicated, and I would suggest that it was not this charge, it was not this assault dangerous weapon charge. Again, this did not bar him from the waiver of criminal inadmissibility. There were a host of other instances. Again, that decision indicated that asked the immigration judge to look at the facts and wanted
But isn't
findings.
that after the time of the plea?
Yeah, it's years after, but let me ask you that. I'm sorry I didn't ask counsel this. What triggered this? What triggered the immigration process?
It's unclear, but I would suggest looking at this defendant's record. It was not that long after he was arrested for a number of drug charges that he was taken into custody.
And that would have been how long after this 2005?
He was taken into custody in 2012, and I believe that's when the drug charges took place.
So let's assume you may not persuade us that the judge was clearly erroneous in finding that he fell below the standard of care. Let's go on to the second prong.
Here, there was no prejudice, and the judge properly found that. Here, the motion judge did not credit the defendant that he would have gone to trial. The motion judge did not.
But the motion judge didn't even mention the third prong of Clark, special circumstances. Didn't even mention it.
I believe that there was a brief reference, but essentially he did not really include that in his analysis. But I would suggest that this is really a credibility argument, that it's up to the judge whether or not it would have been rational for the defendant back in 2005 to have rejected this plea bargain. As the motion judge found, there was a global resolution. This defendant essentially wrapped up 10 charges, 7 that were this particular incident, plus 2 other charges, an attempt, malicious damage of property, and a violation of probation on a receiving stolen motor vehicle.
But isn't the question of what you have to sort of take into account in determining whether something was a rational decision, and isn't that part of, the equation to figure out what it would have meant if he'd known of these immigration consequences?
Well,
and whether it was rational, because, there are reasons why people would prefer prison time to going back to their country of origin.
Certainly, but
prison time isn't going to get him out from under a deportation order if he otherwise meets the qualifications.
That's correct. I would note that in this particular incident,
but laws change in the interim, don't they?
Laws have changed.
They're changing now.
What's important to note that this defendant thought so little of his refugee status, he didn't even tell his attorney that he was a refugee. And that's not burden shifting. I'm not talking about the deficient performance.
How would he know it would matter? I mean, that assumes that he has knowledge that the criminal conviction may have consequence on his immigration status because he's a refugee, but how's he supposed to know that?
Presumably, he has noticed. This is not the first time he's been before the court. He's been before the court a number of times prior to this, not to mention, and I believe this is what the motion judge specifically found, that Judge Payne gave a colloquy. The defendant had noticed that he was subject to deportation.
And he surely knew he was not a citizen, right?
Correct. And the fact that he placed so little import on his immigration status, this is very distinguished from De Jesus. In De Jesus, the motion judge found that the defendant was very concerned about immigration consequences. Here, he thought so little of his refugee status, even though he was on notice.
But nothing happened before. Now, all of a sudden, the walls are coming down on him.
Does it concern you, counsel, that the judge in this case gave short shrift to the federal law provisions about how he was supposed to consider the defendant's status as a refugee and why he was a refugee. I mean, the judge just can't pretend that that's not there.
The judge did not go into as much detail, certainly, as he could have in his order.
Well, you know, I had the distinct impression that the judge said to himself, if not out loud, I don't care about what the federal government says about people in this position. I'm going to do what I want to do with this case.
I think based on the circumstances, based on the fact that this was really a credibility issue for the judge to decide, the judge just decided.
Credibility is at issue with the government's findings about what this person might fear if he had to go back to Russia. That's a credibility issue?
No, as far as the subjectiveness of this defendant's, what this defendant wanted to do back in 2005, that the judge believed that he wanted to wrap up his cases, and that was more important to him, that he had notice. I would suggest to the court that certainly the defendant could have had his parents testify as to what was going on back when they came.
He didn't need to do that. I mean, he had all of that.
Which was 15 years earlier.
Was there any chance that this defendant was going to get indicted?
On this record, I couldn't tell the court.
But I mean, there hadn't been anything in plea discussions that if he pleads to this, we will not seek an indictment. That's not in the record.
No, that's not in the record, Your Honor.
What's the likely sentence that he would have gotten for assault by means of a dangerous weapon in the circumstances of this case had he gone to trial and been convicted?
I don't think it was unreasonable for the Commonwealth to have asked and have received a year sentence.
Okay, so 1 year. That strikes me as probably what the case was worth. And you're saying that the downside risk of 1 year in jail, going to trial, versus being deported to Russia and perhaps forever being exposed to potentially some environment of persecution, that it would not have been rational for him to have gone to trial?
No, I would suggest this is a strong case for the Commonwealth. If he had gone to trial, been convicted, and received a year, this would have been an aggravated felony, and he would have been that would have been mandatory deportation, just like a drug case.
I mean, as you mentioned, none of this even started until he was arrested for additional crimes years later. Right?
That's correct.
And this standing alone wouldn't have resulted in his mandatory deportation.
That's the Commonwealth's argument.
So what weight, if any, should we give to the fact that a defendant is a refugee?
Really, I think...
With regard to prong two, you're saying it's irrelevant?
Oh, certainly not.
Okay, so what weight?
I think that the framework that's been set out in Clark is sufficient. Here, Clark sets out special circumstances, and it's up to the defendant, who has a substantial burden to prove to the judge that he would have placed emphasis on those special circumstances. I would suggest...
Wasn't that the argument that he made?
Yeah, I mean, your brother is saying that the fact that I'm going to be sent to a place for which I have a fear of persecution is a special circumstance.
But I would suggest that this is also hindsight. I mean, I would suggest pretty much every defendant, when they find out they're going to be deported, is going to make this argument. So...
But we have to look at it at the time of the plea. So isn't the framework, had his counsel been effective and provided him with all the advice that Mr. Schnipper said he should be provided with, that I know you are a refugee because I made inquiry, and this is the consequence of pleading guilty to a crime of violence it is a risk with regard to your ability to continue to be in this country, would he still have pled guilty? Isn't that what the issue is?
Yes, and I would suggest the risk, and I come back to within the framework of Clark, within those the three prongs, for lack of a better term, but along with whether or not the defendant proves his substantial burden that he would have gone to trial, and because this was a risk. This was a risk, and he was.
But risk is a probability, but the fact that you're a refugee speaks of the magnitude of the consequence. I mean, risk times danger, but it's a difference between saying, you know, I came here from France and I may have to go back to France versus I came from Honduras and I may have to go back to Honduras where I will be killed.
But I think that's different. If a defendant were to testify in an evidentiary hearing, as we had, saying, I am afraid to go back because I may be killed, because this defendant couldn't, he couldn't remember. He didn't,
But isn't that always true when you come as a child?
he was 13, Your Honor.
Oh, okay. You think back to 13, what did you know?
I don't know, but I think if it was fearful and my family was afraid that we would be killed, I think that's something I would remember, but I'm not in the defendant's position.
But what do we do with the fact that the government so found? And the government said you are a refugee. There are findings implicit. There are findings implicit in granting you refugee status.
But again, it's the subjectiveness that this defendant did not testify to that, and the fact that all he said was essentially is relying on the fact that I'm a refugee, and I would suggest that the framework that has been set out in Clark, if the defendant had said, I am fearful, or if I'm very fearful of going back, I would suggest that the motion judge might have weighted that a bit more heavily.
So when he's suggesting, I'm just confused as to time. The judge in cases, is this the case where the judge had an evidentiary hearing on a motion for reconsideration? Is that?
That's correct. That's correct.
So at the time of the plea, nothing was said about this, right? In 2005, we don't have that record anymore anyway, right?
That's correct. So we don't know what was.
We don't know what was said. So when the hearing was held now, the defendant testified?
The defendant did testify.
And said that back then I was.
He didn't recall what the circumstances were. He knew he came from Russia. He knew that there were some church burnings, but that was it. That was really the extent of his testimony as far as that was concerned. He also testified as to what was who else had come with him and that sort of thing. Because the framework in Clark has set out the circumstances, the Commonwealth would ask that certainly no presumption be put in place. Commonwealth would ask that you deny, on these facts, would affirm the.
So let me be clear. No conclusive presumption for sure.
For sure.
How about a rebuttable presumption?
The Commonwealth would suggest that that Clark already covers that, and it's up to a defendant who, again, has a substantial burden to prove to the judge.
So a factor?
Certainly a factor, certainly, but it already is a factor.
So it's a factor whose weight needs to be determined by the motion judge, is what your position is.
Yes.
Okay, thank you.
Thank you.
We'll take our morning break unless folks, I've only sat on 2, so do folks want to continue for a 5th?
Sure.
Okay, they're ready to hear the 5th, so we'll hear the 5th case and then take our break after that.